The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer the question of when is a contract valid if it's not signed by both parties. So let's start with some basic principles here. Oral contracts are contracts. They are exceedingly hard to prove, but an oral contract can be valid even if it's never reduced to writing. So a contract requires offer, acceptance, and consideration. Consideration is just the exchange of value between both parties. If all of those three things are present, you don't even need a contract to be in writing to be valid. Except there are certain types of contracts, which we discuss in more detail at learn-about-law.com, that fall within something called the statute of frauds. And the statute of frauds requires that contracts of a certain type, and there's a list of about 7 different types of contracts, need to be in writing in order to be valid and need to bear the signature of the person who's being held responsible for them. So whoever is claiming that the contract isn't valid, it needs to have their signature on it in order to be valid. So here we're talking about contracts that aren't a simple handshake agreement. They're not contracts that fall within the statute of frauds, so not in that select group of contracts that have to be in writing and signed. We're talking about contracts that have been reduced to writing and have only been signed by one party. So this is a situation where one of the parties sends the other party a contract with a signature, and then the other party starts to act on the contract. And can the parties get out of it saying, well, it's only been signed by one party, so it's not a valid contract? There are basically 3 principles, and they're all kind of related, that deal with this situation. There's 3, and there are kind of 3 times when these contracts have held up. And when we say hold up, it's not like an oral contract where you have to kind of prove all the terms. It's we have a writing. Everything in the contract is considered to be valid, even though it's been signed only by one party, and we're not arguing about the terms of the contract. So one principle here is that if the parties have acted in a way that's consistent with the written agreement, even if both parties haven't, or even if one of the parties hasn't signed it, the written agreement will hold up generally, as long as it doesn't fall within the statute of frauds. So this is a situation where, a business is providing a service to another person or another business. They send a contract over that requires monthly payments, and the other party never signs the contract, but the service is provided and monthly payments are made. So both parties are acting as if they had both signed the contract. In this case, the parties will be bound to the terms of the written contract. Another situation is when the party who is trying to be held accountable for the contract failed to object to it at the time and then continued to act. So this is very similar, but a situation that we use as an example is if the parties are agreeing to paint a house and they've said, okay, I'll paint your house for, $5,000. And then the person who's contracting to have their house painted sends over a contract for the painter to sign in which a time frame is specified. The painter thinks the time frame is unreasonable, but never objects to it, never says, no, I can't do it in that time frame, and never says, no, I'm not going to sign your contract. The painter doesn't sign the contract, but just goes ahead and paints the house. In this situation, if the painter takes longer than that time frame, they may be held accountable for it because they've acted it's acting in a way consistent with the contract. They've given the other party no reason to believe that they found the time frame unreasonable. Going forward with the contract without objecting after the written contract had been sent over is a good argument that the contract should be held up. And that leads us to our final point, is that if the contract is held valid for one part of the written contract, the entire written contract is valid. So when we talk about the time frame included in the house painting contract, if a court were to find that yes, the person's required to go to paint the house within that time frame because he didn't object to it, then it's not just that time frame portion of the written contract that is considered to be valid, it's the entire writing. And that's what differentiates this from an oral contract. In an oral contract, you're required to basically prove all of the terms of your agreement and what the meetings of the mind are. Here, when we're talking about a written contract that's only signed by one party, you just have to show that the underlying contract is valid because the parties acted in a manner consistent with it. And then now you've got a writing where every word of that writing should be valid contractual language that both parties can be held accountable for. So if you have any questions, please post them in the comment section below this video on our YouTube station or below the post at learn-about-law.com. We love answering your questions. We try to get back to you within about 24 or 48 hours. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud. And feel free to call us for a free consultation at 630-324-6666. That's 630-324-6666. We offer free consultations in almost every area of law, and we have offices all around Chicagoland for your convenience. Thank you so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.